Here's a video on what people in government or outside government can do if they don't like what the Supreme Court said in a ruling. The question really is not what they can do, but how likely any of it is to work. Here's what Congress can do. They can impeach a justice. Okay, straight up, this isn't going to work. We've seen how difficult it is to get 2/3 majority in the Senate to convict and throw a justice out. And ever since when Jefferson was president and they tried to impeach a justice for his rulings, and that failed, we have the precedent that justices will not be impeached based on what their rulings are, that they can only be impeached for some sort of crime, such as bribery. We've never thrown out a justice from the Supreme Court. They have impeached and convicted a few federal judges on the lower court level, and that was for bribery. They can freeze judicial salaries. The Constitution forbids lowering the salaries, but they can freeze them. But that's not going to work. I don't think any of the justices on the court are on it because they want the money and they're worried that they won't get an increase next year. First of all, they've made money and they saved it before they got on the court. And all of these justices could have made a lot more money if they had stayed in private practice. I remember reading that when John Roberts was nominated to be Chief Justice, that he was giving up millions of dollars in private practice a year that he could have been making when he went on the court. So just forget that. It is possible to change the number of justices on the Supreme Court. There's nothing in the Constitution that says there has to be 9. And this has been tried in the past. Most recently, when FDR was president, he unsuccessfully tried to increase it to 15 after he won the 1936 election, and the Senate just wouldn't go along with it. You've heard a few Democrats now saying if they win the presidency and they win the Senate and keep the House, they're going to change the number of justices on the Supreme Court. I don't think they would. I don't think they would get all Democrats to vote for that, no matter how angry they are, because they realize the Republicans could come in and do the same thing, and it would be extremely unpopular with the public. So forget that. They can try to remove appellate jurisdiction of the court, saying that there's certain subjects the court can't rule on. I remember in the 70s, there were some people who said, let's just say they cannot rule on abortion cases. That went nowhere. Occasionally, experts talk about this. It is something that could be done. It would be very hard to get through Congress, and no one's done it except during the Civil War to remove their jurisdiction over habeas corpus cases, and that left after the war was over. So then we get to things that maybe could have a little more success. The Senate could use its advise and consent powers to only approve nominees that they think would vote against a previous decision. But think of what has to happen. A justice who was in the majority, let's say someone who was in the majority in the gun rights cases, which were 5-4 decisions, one of the 5 has to die or retire at the time when a president of the other side of the argument is in power and when the Senate is controlled by the other party. And the president has to trust a nominee would vote in a different way without ever being able to ask, how are you going to vote on a gun rights case? And the senators can't ask, how are you going to vote? So they would just have to hope. And there have been lots of cases, not cases, but examples of people who've been nominated to the court. And once they get on the court, they get their lifetime tenure and they don't vote the way the president was hoping they were going to. Most famously, when there were 5 justices on the court who had been appointed by Republican presidents who were against Roe v. Wade, people hoped that the court would overturn Roe v. Wade in the Casey decision in the early 90s, and they didn't do it. because you can't depend on somebody who has lifetime tenure voting a certain way, and everything has to line up. They can revise a statute that was deemed unconstitutional. If the problem was that the statute, how it was written, was vague and didn't give the power that a federal agency was using it for, that's something that could be rewritten. For example, Congress writes a vague law that the EPA determines allows them to regulate a certain type of pollutant that wasn't mentioned in the law in the first place. And the Supreme Court says, no, you don't have the power to do that. Well, then all we need is Congress to rewrite that law. As long as it doesn't involve some constitutional right, such as freedom of speech, and all it involves is the interpretation of what the statute says, all they need is to make it more clear. So that's something they can do, and has been done lots of times. The problem is you need majorities in both houses to revise the statute and a president who will sign it. So everything has to line up once again, but it can be done. They can propose an amendment to overturn a decision. This is hard to do. You have to get 2/3 of both houses and 3/4 of the states. That's difficult. It's been done 4 times in our nation's history, and thus we have the 11th, 14th, 16th, and 26th amendments all came about to reverse Supreme Court decisions. So, for example, the 14th Amendment established that all people who were born here or naturalized are citizens, and that reversed Dred Scott, which had said that blacks could not be citizens. So it can be done, but it's difficult. Okay, what can the president do? Well, he can huff and puff and use his bully pulpit to complain. Maybe this works. Maybe it will intimidate the justices. I don't really think so. Some people think John Roberts was intimidated when the Obamacare decision was before the court by things that Obama had said. Who knows? Who knows what went through his head? But we have talked previously that the court is very conscious of its public standing. They don't want to get out too far ahead of the public on an issue. So maybe it could have some influence. But remember, these people have lifetime tenure, and I fully believe they make their decisions based on what they truly believe is the correct thing to do, even when I've disagreed with decisions. I don't think they're doing it because, this is wrong, but I'm going to do it anyway. Supposedly, the president could ignore enforcement of the law. Most famously, this happened with Andrew Jackson and the decision that the court made in a case called Worcester v. Georgia, saying that Georgia could not take the lands of the Cherokee Indians within the state. They did. Jackson ignored that and didn't enforce the decision. I think that's a lot harder to do these days, what with public attention, media, social media, and there could be challenges brought trying to force the executive branch to enforce a decision or force a state government to enforce the decision. I think it would be a lot harder to get away with ignoring a decision today. The president could nominate a new justice who would vote against a similar decision if a new case came before the court. Think back to what I said in the previous slide, all the things that have to come together for one of the justices who was in the majority to die or retire, and then for it all to line up that the president and the Senate were controlled by the party that didn't like the majority decision. And you have a new justice who would follow through on the way people thought he or she would vote. It's a bit iffy. It may or may not happen. We have seen decisions change because the justices on the court have changed. We saw Citizens United being that came in 2010, and there had been a difference on the court between Sandra Day O'Connor, who had voted to approve the original McCain-Feingold or Bipartisan Campaign Reform Act when it first came before the court, and now here was a case that was chipping away at part of that law, and O'Connor had been replaced by Samuel Alito, and he voted in the majority that struck down that provision about banning ads by corporations and labor unions 30 days before primary, 60 days before a general election. There you can see a change in one justice made a difference. And so presumably, if there were a change and a Democratic president nominated a justice and the Democrats controlled the Senate, and the justice who was being replaced had voted in the majority in Citizens United, there could maybe be some sort of challenge of a similar sort of case, or maybe we could see a gun rights case that was also a 5-4 decision, but everything has to line up. Okay. So the president can do a lot of huffing and puffing about the court and try and use the bully part of the bully pulpit, but it's not clear how much that would work. And remember, the word bully and bully pulpit doesn't mean what we think it means today. It meant what Teddy Roosevelt was using it for, to saying it's really cool, it's a great tool. Okay, I just wanted to make that clear. What can interest groups do? Well, they can launch protests, and that may or may not work. You have a lot of huffing at the Supreme Court, but I don't know how much they care. If the problem was that there was a law that was deemed vague, they can try and pressure legislators to write a new law to make it more clear. They can use in-person lobbying or grassroots lobbying. They can put pressure on politicians when a new nomination comes up, and we've seen in the recent past it becomes so antagonistic when there is a new nominee, and a lot of pressure is put on, and the president may or may not be listening to that. They could look for new opportunities to bring a case, to chip away at the decision. We've seen pro-life groups do this when they chipped away at certain provisions regarding abortion, such as requiring minors get the consent of a parent, or that there be a 24-hour waiting period. So they could chip away, but they haven't been able to overturn the right altogether. If there were one of these cases that they think they would have an opportunity, they can really go for it. I think that's what we're seeing with the group that is bringing the case about affirmative action and Asian Americans at Harvard. There is a group that's been formed to help fund this, and they're hoping that it will get to the Supreme Court, and because Sandra Day O'Connor has been replaced and she had voted in the majority in the Michigan law case, Grutter v. Bollinger, that maybe they would get a different ruling today. So if it does get to the court, you could see how that played a role. And they can submit a amicus brief. Is there some new case? They can really get involved in that. People, they can protest, they can join an interest group, they can lobby their legislators. That may or may not work, but I don't know how much the Supreme Court really cares that there are crowds screaming outside the building. So think back to our first day and Alexander Hamilton's Federalist paper saying that the